situation, that person should receive incarceration or receive this or that. So yes, they're necessary. One, we should have input, and one, in another type of situation, district court judge should not have input. Thank you.
Plea bargaining and sentence bargaining are essential to our criminal justice system. You just have to understand the volume of the cases that we're dealing with. And that will tell you, you just can't try every case if there's thousands that you're handling. Ms. Barnes has mentioned, last time she spoke, 300 or 400 in the first 3 or 4 weeks that she was in, said she had handling. And those, you're working with volume and you work with resolution, but you try the cases that need to be tried and the others you resolve. And a lot of them have the plea bargain with the prosecutor. Some will have with the sentence bargain, they won't offer the plea bargain. Sometimes a judge can get involved in what's called a Cobb's indication. Happens quite a bit in district court and circuit court. You let your client know that I'm going to give him a $200 fine for urinating in public, and they'll move the file. Just because it's the second time and the prosecutor won't reduce it. You're going to wind up, again, when you get in this position, you will try the cases that need to be tried, and the others you're going to look, and I think you should help to resolve. Thank you.
The district court, you handle between about 100 cases a week, and so I agree with everyone else that plea bargaining is necessary and important, because without it you can't possibly move the volume of cases that comes through the court. However, I have on a couple occasions already called the prosecutor into the courtroom to explain their offer. That's a place where the judge needs to be able to take a stand, because our job ultimately is to protect the interests of the public. So if you've got a person and you pull out their criminal history from a little manila envelope that's in the file and you pull it out and it stretches from here to the floor and the offer is no jail, you may wish to understand why that is. Now, I was a prosecutor, and most of the time when I made those sweet deals, it was because my case was terrible. My witnesses had left the state, people had died, you know. The breath test was going to be challenged, and it should be. I was going to lose my breath test on a drunk driving case. I had a case where an officer left the blood in the trunk for 3.5 months without sending it to the testing. So you have to sometimes give those sweet deals, but the judge needs to understand why it's being given, because it's being given because of a careless reason. You have to stop it.
As Mr. Jacobs said, judges are basically without authority to either force or to stop a plea bargain. That is between the prosecutor and the defense lawyer and their client. Just as in a civil case, a judge can't force a plaintiff and a defendant to settle for a monetary amount. What a judge can do, and under certain circumstances should do, is facilitate the negotiations between the parties. And it's not just a matter of clearing up a docket. Sometimes it's a matter of fairness. Sometimes it's a matter that the person may be charged with a more serious crime than is just. Or, as Judge Barnes said, sometimes even though you think the defendant has done a horrible thing, the prosecutor may have difficulty in proving it. So there are lots of reasons for it. The judge's ability to bring it about is somewhat limited.
Describe the function of the court you are running for as you understand it today, and give one suggestion to improve its functionality.
Describe the function of the court as it is today in a suggestion. The district court is the people's court. This is where you get the majority of people. There's a lot of people in this room that would never appear in the district court unless they were involved with speed ticket, OUIO, or landlord, or something like that. Function of the court then is the people's court, to serve the functions and help the people who show up in the court that are common people. How can, one of the things about the district court is that you have to have a sensitivity to the type of people that show up. You can't be too mild-mannered, too liberal, and be willing to let the people feel that the court isn't there for their reason or for their use or for their purpose. One of the things that courts need to get an improvement on is the way that people are treated and the way that cases are handled on a more rapid way. Cases have to be expedited and handled more quickly.
When I gave my introductory presentation, I mentioned that I've been going door to door and question of education in our system, district court, circuit, probate court. As I mentioned, I had a discussion with Judge Newcomb. There's no question there's volume in district court, whether it be landlord-tenant, whether it be misdemeanor, traffic offense, et cetera, But the one thing that Judge Newcomb indicated, we don't have law clerks in district court. And when you handle the civil cases, you have to do it on your own. Now, I've been doing my own research for years. And one of the functions of the judge is to handle civil cases. I've been pushing, and Bay County has missed this, with the State Court Administrator's Office and mediation. We do mediation everywhere. I've sat as mediator, Genesee County, all over. I was in Genesee County on Friday. This is something we will implement when I become a judge. Thank you.
Sounds like I'm beating a dead horse. Again, I go back to the treatment. That's what I'd like to see. I mean, you read some of these studies, folks, it costs over $30,000 a year to house a person in the criminal justice system. We don't need to house people, we need to help people. So what would I like to see? I would like to see a veterans court. I would like to see a broader type of treatment court where we're helping people and getting them out of the system instead of coming back into the system over and over again. Thank you.
As you're aware, 75% of the district court work is this criminal work. And when you're working in district court, the cases you're sentencing or having trials on are misdemeanors. But where public safety, it doesn't really come involved as much in misdemeanors because they're just not that serious of a crime. Where district judges get involved in more serious decisions are with felonies and bond considerations. And right now, we have Matt Romeo, who's the staff person for pretrial services. He's hired through the sheriff's department, and what he does is he assists the judges on bond. And once they've been held, they got 14 days to start their preliminary examination. There's that time period that we need to have somebody like Matt Romeo, that competent, to do up workups for us judges for what the bond should be and what conditions, so that we can, as judges, make better decisions on who should be out there and who should be incarcerated. And right now, he's being cut back because they don't want to take it on a full-time responsibility. And it's time for district judges to step up and get that guy a full-time job.
The single most important thing you can do, what's actually within your power and control as a district court judge, is how you handle your own docket. And how I handle my docket is I don't leave until it's done. I don't leave until it's done. If my inbox is full, I make sure it's empty before I leave for the day. If there's work to be done, I do it before I go. And I do that every day. I get up in the morning, I repeat the process. I can't control what the prosecutors do on their end. I can't control what the defense attorneys do. I can't control the fact that Mr. Daner has to be in six courts at once, every day. And then the same thing that happened when I was a defense attorney. What I can control is that when they are ready to go, I'm ready to go. I've read the file. I know what the facts and circumstances surrounding the case are. And I am ready to take the bench at any moment that they are ready for their case to be heard.